Hi, Jim Solbach. Today I want to talk about the second requirement for a willful violation, which is a deliberate act. And we know the two things that you need for a willful violation is any deliberate act taken in violation of the state which the debtor or the creditor or violator knows to be in existence. So properly notified takes some deliberate act. Now, for most situations, a deliberate act is pretty obvious. They sent a letter, they sent a bill, they sued them, they made a phone call. But a deliberate act can also be the failure to act, because under certain circumstances, a creditor has an obligation to do something, and if they fail to do that, that constitutes a deliberate act. Let me give you an example. Foreclosure action is started before the bankruptcy is filed. The attorney submits a judgment to the state court before the bankruptcy is filed. So that lawyer knows that that judgment is sitting on that judge's desk. The attorney is then notified that this person has filed bankruptcy. So what does he or she know? The person is protected by the automatic stay. The property is property of the bankruptcy estate, and that judge has an order of foreclosure that he hasn't signed yet, involving that debtor and that property. So, in this particular case, for 8 days, the lawyer did nothing. All he or she had to do was simply call the state court and say, "Judge, I just was notified that there was a bankruptcy, so please don't sign that judgment." Didn't do that. So that state court went ahead and signed that judgment. That, in my view, is a deliberate act. That's the failure to act, and that results in a willful violation. This is what Judge Cangelos Ruiz said about the duty of a creditor to act. Once a creditor has put the wheels of collection in motion against the judgment debtor, upon learning of the filing of the bankruptcy by that debtor, the creditor must ensure that the wheels of collection come to an immediate halt. So you can't say, "Hey, I didn't sign the judgment, I didn't do it, he did it." No, what Judge Cangelos Ruiz is saying is the obligation is on the creditor and the creditor's attorney to act, to get that stopped. So if it could be a wage garnishment, once they're notified, you got to make sure and follow up that garnishment comes off their wages. Could be a bank restraint, could be anything. So the failure to act can also be a deliberate act.